Mei Ling is 42 years old. She has been working and contributing to CPF for 19 years. Her balance today is $180,000. She believes her CPF nomination is in order. She made one 9 years ago when she first started thinking about these things. She is wrong. She got married in 2018. Under Singapore law, marriage automatically revokes a CPF nomination. The moment she signed the marriage certificate, her old nomination became void. She has not made a new one since. She has 2 children, 9 and 14 years old. They are not on any nomination because the nomination she thinks exists does not exist. If Mei Ling dies tomorrow, her $180,000 does not go to her husband. It does not go to her children. It goes to the Public Trustee's office, which will take up to 6 months to identify the legal beneficiaries, charge an administrative fee that cannot be waived, and distribute the money based on a law that has no idea what she would have wanted. This is not an unusual situation. It is the median situation. According to MOM's parliamentary response in February 2025, 64% of CPF members between the ages of 16 and 65 have not made a valid CPF nomination. Not 64% of young people who have not thought about it yet, 64% of the entire working age CPF membership. Most of them, like Mei Ling, believe they already have one. Your CPF does not automatically go to your family when you die. And a will, no matter how carefully written, no matter how expensive the lawyer, cannot distribute your CPF. These are 2 facts that most Singaporeans either do not know or have forgotten. This video will cover exactly what happens, what the real numbers look like, and the 4 things you need to do before you finish watching. Start with what CPF nomination actually is and why it is completely separate from everything else you have done with your estate planning. CPF savings do not form part of your estate. This is not a technicality. It is a fundamental legal distinction that changes everything. When you die, your HDB flat, your bank accounts, your CSPX investments, your jewelry, these form your estate and are distributed either by your will or, if you have no will, by the Interstate Succession Act. CPF is outside all of that. A will cannot touch it. A lawyer cannot include it. If your will says, "I leave everything to my wife," that everything does not include your CPF. CPF has its own separate legal track, and the only instrument that controls that track is a CPF nomination. A CPF nomination is a direct legal instruction to CPF board telling them who receives your savings in what proportions when you die. You can nominate anyone, your spouse, your children, your parents, a sibling, a friend, a charity. They do not need to have a CPF account. They do not need to be a Singapore citizen. You can nominate up to 15 nominees online and allocate proportions down to 0.01%. It costs nothing to make. It takes approximately 20 minutes online through SingPass with 2 witnesses who can be CPF staff at any service center. Once a valid nomination exists, when CPF board is notified of your death, they contact your nominees within 10 working days. The nominees access the deceased CPF member dashboard through SingPass, see the full account statement, and receive the money in cash through PayNow or Giro. The whole process typically completes within 5 weeks. No fees, no court, no lawyer, no probate. That is the system working correctly. Now here is the system when it goes wrong. Faraid is 51 years old. He divorced 3 years ago. He made a CPF nomination in 2018. His wife at the time was the sole nominee. After the divorce, he did not update the nomination. He did not think about it. He met someone new, has been with her for 5 years, and assumes that if something happens to him, she will be taken care of. Here is what the law actually says. Marriage automatically revokes a CPF nomination. Divorce does not. The nomination Faraid made in 2018 is still legally valid in 2026. His ex-wife remains his sole CPF nominee. His current partner has no legal relationship with him, no nomination in her name, and under the Intestate Succession Act, she would receive nothing through intestacy either, because they are not married. His CPF balance of $320,000 would go to his ex-wife in full if he died today. This is not a theoretical risk. CPF Board has published this warning explicitly. A marriage revokes a nomination because the law treats marriage as a material change in personal circumstances. A divorce does not revoke a nomination because the law treats that as a matter the nominator should manage actively. If you got divorced and never updated your nomination, your ex-spouse may still be your CPF beneficiary right now. There is a second version of this mistake that Faraid's situation could have been. Imagine he had updated the nomination after marriage in 2018 to include his wife and forgot to update it again after they had children. Under intestacy law, once you have children, your parents are excluded from inheriting. But a CPF nomination is not intestacy law. It follows exactly what you wrote, regardless of whether that reflects your current family situation. A nomination that leaves everything to a spouse and nothing to children born after the nomination was made will distribute exactly as written. The children will receive nothing. CPF Board documented a real case. A man made his nomination before his youngest child was born and never updated it. When he died, the older children asked CPF Board why the youngest received nothing. The answer was that the youngest child was not on the nomination because the father never added them. CPF Board did not make an error. The nomination was executed exactly as written. The action. Go to cpf.gov.sg/view nom details right now using SingPass. Check whether a nomination exists. Check who is on it. Check whether it reflects your actual intentions today, not your intentions when you made it. Now the numbers that most people have never seen. When Mei Ling's $180,000 goes to the Public Trustee's office without a nomination, the PTO charges an administrative fee before distributing anything. This fee is prescribed by law, includes GST, and cannot be waived under any circumstances. Here is the actual fee schedule from the Ministry of Law. On the first $1,000, 2.4%. On the next $9,000, 1.5%. On the next $240,000, 0.75%. On the next $250,000, 0.45%. On any amount above $500,000, 0.3%. For Mei Ling's $180,000, the PTO fee is approximately $1,350. That is $1,350 taken from her children's inheritance before they receive a cent. For someone with $300,000 in CPF, the fee is approximately $2,190. For $400,000, approximately $2,630. These are not large numbers relative to the balances involved, but they are not zero, and they come with a 6-month wait, during which Mei Ling's family has no access to these funds, during which they are navigating paperwork and grief simultaneously, during which the PTO is tracing legal relationships and requesting marriage certificates, birth certificates, and identity documents from people who are already dealing with a death in the family. The nomination costs nothing. The absence of a nomination costs time, stress, and money that goes to an administrative process rather than the people it was meant to reach. There is one additional layer that catches people. Mei Ling's children are 9 and 14. Under Singapore law, a CPF nominee who is under 18 cannot receive the money directly. Even with a valid nomination naming her children, any portion allocated to a child under 18 goes to the Public Trustee's office in trust until the child reaches 18. The PTO charges fees for this trust management as well, at the same tiered rate as unnominated CPF. The money earns interest in trust, but the PTO takes a fee on that interest too. This is not a problem if you understand it. It is a serious problem if you assume the money would go directly to your spouse to use for the children's expenses immediately. Now the piece of this that surprises almost everyone. David is 58 years old. He has CPF at the Enhanced Retirement Sum level, $440,800. He is enrolled in CPF LIFE. He has made a valid nomination, updated after his third child was born. He believes his estate planning is complete. He has missed something. CPF LIFE is an annuity. When David started receiving payouts at 65, his RA balance was used as the premium for the CPF LIFE scheme. The scheme then pays him a monthly income for life, $1,780 to over $3,000 depending on the tier, for as long as he lives, even after the original premium is fully exhausted. Here is what happens to that premium when he dies before exhausting it. The CPF LIFE premium balance, calculated as total premium paid minus total payouts received, is distributed to his nominees together with any remaining savings in other accounts. The interest earned on the premium does not go to the nominees. The interest flows into the CPF LIFE annuity pool to fund payouts for members who live longer than expected. Only the premium balance itself goes to the nominees. The practical implication: if David paid a premium of $440,800 and dies after receiving $180,000 in payouts over 10 years, his nominees receive $260,800. If he dies after receiving $400,000 in payouts over 22 years, his nominees receive $40,800. If he lives long enough that the cumulative payouts exceed the original premium, his nominees receive nothing from the RA, but CPF LIFE continues paying him until the day he dies regardless. That is the point of the scheme. David's CPFIS investments, the $85,000 in CSPX he bought through CPF investment scheme, are a completely different matter. CPFIS investments are not covered by CPF nomination. They form part of his estate and must be claimed through probate by an executor or administrator. If he has a will, the executor handles this. If he has no will, his family must apply for letters of administration before anyone can touch those shares. This process takes months and costs money. David's nomination covers his OA, RA, and Medisave balances. It does not cover his CPFIS portfolio. This is the part of CPF inheritance planning that even financially sophisticated Singaporeans overlook. The nomination and the will are both necessary. They cover different assets. A will without a nomination leaves CPF stranded at PTO. A nomination without a will leaves CPFIS investments in administrative limbo. Both are required for a complete estate plan. Now the Muslim inheritance question, because the rules here differ significantly, and this affects a substantial part of Singapore's population. Amina is 38 years old. Her CPF balance is $95,000. She supports her parents financially. They depend on her monthly contribution for household expenses. She has no nomination. She has no wasiat, a Muslim will. She has brothers who she is not close to. Under Singapore law for Muslims, CPF savings without a nomination are distributed according to Faraid, Muslim inheritance law, administered through a certificate of inheritance issued by the Sharia court. This is not the same as the Intestate Succession Act. The shares allocated to different family members under Faraid follow rules prescribed by Islamic jurisprudence, which differ from civil intestacy in their treatment of parents, siblings, and gender. The process: the family must apply to Sharia court for a certificate of inheritance, which is then submitted to PTO. The PTO distributes according to that certificate. The timeline: longer than the standard civil process. The family situation, estranged brothers, dependent parents, is managed by law, not by Amina's intentions. The Fatwa Committee of MUIS ruled in 2010 that a CPF nomination by a Muslim is permissible under Islamic law as a form of hibah, a gift made during one's lifetime that takes effect upon death. This means Amina can make a CPF nomination and direct her savings exactly as she wishes, including prioritizing her parents over her brothers, which Faraid alone would not necessarily achieve. The nomination is not a substitute for proper estate planning under Islamic law, but it is a legitimate and explicitly approved tool for directing CPF savings independently of the standard inheritance distribution. If Amina wants her parents to receive her full $95,000, she can nominate them now for whatever proportion she chooses. Without a nomination, Faraid governs. With a nomination, her intentions govern. Here is the complete picture of what your CPF nomination covers and what it does not, because these are frequently confused. Your nomination covers all balances in ordinary account, Medisave account, special account if you are below 55, retirement account, and your CPF Life premium balance if you are enrolled in CPF Life. If you hold discounted Singtel shares through the Special Discounted Share Scheme from 1993 or 1996, those are also covered if indicated. Your nomination does not cover any property purchased using CPF savings. The property is handled separately based on how you hold it. Joint tenancy means the property passes automatically to the surviving owner without nomination or probate. Tenancy in common means your share goes through your estate. CPFIS investments, shares, ETFs, unit trusts bought through CPF investment scheme are part of your estate and require probate. The DPS payout of up to $70,000 must be claimed directly from Great Eastern Life by your family. The HPS payout goes to settle the outstanding home loan, not to nominees. If you have CPFIS investments and have not written a will, your investments sit in administrative suspension until your family applies for letters of administration. Write the will. Mei Ling checked her nomination status that evening. She saw the old nomination, her name before marriage, 2 witnesses from 2015, with the words CPF member typed across the top. Void. Revoked automatically on the day she married. She made a new nomination that night. Online. 22 minutes. 2 colleagues as witnesses. They acknowledged digitally within the day. She nominated her husband for 60% and set aside 20% each for her children. She noted in her records that when her younger child turns 18, she will revisit whether to adjust the children's proportions. She also made a mental note to check this every January, alongside the SRS top-up and the CPF cash top-up she does every year. 1 review. 3 things at once. Faraid updated his nomination the following week. His current partner received 50%. His mother received 25%. He left the personal letter, not legally binding for CPF purposes, but clear in its intent, explaining his reasoning. His ex-wife received nothing, as he intended. David found out about CPFIS 3 days later when he called his advisor. He wrote a will the following month. $85,000 in CSPX, now covered. His CPF nomination and his will together cover everything he owns. Your CPF savings represent decades of work, 37% of your salary. Every contribution you ever made, every top-up, every year of compounding at 4% that built your retirement account to where it is today. None of that matters if the person who receives it is not the person you intended, or if it arrives 6 months late, reduced by fees, distributed by a law that does not know your family. The nomination is free. It takes 20 minutes. It requires SingPass and 2 witnesses. 4 things to do before you close this video. First, go to cpf.gov.sg/viewnomdetails. Check whether a nomination exists and who is on it. Second, if you got married after your last nomination, you have no nomination. Make a new one today. Third, if you have CPFIS investments, shares or ETFs bought through CPF, write a will. The nomination does not cover them. Fourth, if your family situation has changed since your last nomination, divorce, new children, death of a nominee, new partner, update the nomination to reflect who you actually want to receive your savings. The deceased CPF member dashboard is waiting for someone. The question is whether it contains what you intended.